I'm Mary Kissel with the Wall Street Journal editorial board, and I am joined again by Jennifer Gratz, founder and CEO of the XIV Foundation, to talk about race and its place in university admissions policies. Jennifer, you had a huge fight on your hands in the last decade trying to get race taken out of admissions in the state of Michigan. It was a hard battle, but you won, yet it's being challenged yet again at the high court. What is at stake here?
Well, what's at stake is whether the people have the right to tell their government that they want to be treated equally without regard to race, which it's ironic that in 2013 we are still fighting this, nearly 50 years after the Civil Rights Act was passed, that we are fighting for every individual's right to be treated equally by our government.
Okay, now you're very vocal in supporting that point of view. There's another group that is very vocally opposed to you. That's a group called By Any Means Necessary. They've been on the scene for a long time. What kind of tactics are they using to make their argument?
They are a radical group. They've been on the scene since I filed my lawsuit. They were part of my opponents when I was suing the University of Michigan. They counterfeited tickets to get into the Sixth Circuit Court of Appeals when my case and Barb Gruder's case was before the Sixth Circuit in Cincinnati.
That was so 2003.
2001.
2001,
yeah.
Okay.
Yeah, they counterfeited tickets to get in there. They bus in kids from elementary and middle schools, and while those kids are on these buses to different protests, they rile them up and they talk about how we're racist for believing that we deserve a right to be treated equally. They bring weapons to different events. When my case was in front of the U.S. Supreme Court back in 2003, there were massive protests that BAM organized, and they walked around with these dolls on nooses, and my name and Barb Gruder's name were on these dolls. These are the types of tactics that this group, that is now being treated as a mainstream group and part of the defender of this lawsuit, this is who we're bringing into the mainstream right now.
Okay, so the case is Schuette versus By Any Means Necessary. These kinds of hardball tactics, have you been threatened personally, and do they continue to this day with this case?
Yes, I have been threatened personally. I've had different weapons brandished in my presence, which I believe were meant to intimidate me. They don't, but it's a serious thing. They are a radical group, and there's no telling what they might do to try to continue these policies.
What's the outcome that you want to see with this case?
Well, I think that the outcome will be that the people's vote is upheld. The people have a right to vote to restrict their government from using race preferences in college admissions, public contracting, and public employment, and that's what the people of Michigan did.
Okay, well, we're going to be watching the case closely. We hope you'll join us again. Jennifer Gratz, thank you so much for being with us.
Thanks for having me.
Hi, I'm Mary Kissel with the Wall Street Journal editorial board. Joining me today is Jennifer Gratz, founder and CEO of the XIV Foundation, named after the 14th Amendment. Jennifer, thanks so much for being with us. You were a plaintiff in one of the most important Supreme Court cases over the last couple of decades when it comes to race-based admissions. We had a big decision earlier this week from the Supreme Court, Fisher v. the University of Texas. What was your take on that ruling?
I thought that the ruling was decent. The court didn't overturn Gruder, which is, of course, what we all hope for one day.
And Gruder is, for those who don't know it?
Gruder is, Barbara Gruder sued the University of Michigan's law school, and in that case, race preferences were upheld for about another 25 years. I'm not sure how our Constitution changes in 25 years, and we're now 10 years in. But that is what we were hoping Fisher would, or another case would eventually overturn. But the fact is Fisher's attorneys didn't ask the court to overturn Gruder, and I don't think that we can expect the Supreme Court to make bold decisions if we're not willing to ask them to make bold decisions. So I am okay with what the court did. I think it reaffirmed the fact that Gruder was not an open ticket for universities to use race preferences, that there are nuances to that decision, and I think that it slapped not only the University of Texas, but all universities on the hand and said, we were serious when we said that there were these nuances, and that it is not an open ticket to use race preferences.
Now, you've been through this process before. You won your case at the Supreme Court back in 2003. Can you relate to what Abigail Fisher went through? And you know, she has to go back to court now, doesn't she? That her case hasn't been fully decided.
No, I relate to her, I think, in many ways. I haven't spoken with her, but many people forget that I won my case because Barb Grutter lost her case, and it was a personal victory for me, not a principled one. And so I think that I can relate to Abby in that she likely had people calling her yesterday, congratulating her, family and friends, and at the same time there were attorneys debating who won this case, and and so she's standing up claiming victory, and yet so is the University of Texas, and that can be emotional, it can be draining, and so I really, my first thought yesterday when the decision came out and when it was a nuanced and a very narrow decision, I thought about her and her as a person. So often we think about these cases as policies on paper, and we forget that there are real people behind them who have had their dreams dashed because of discrimination.
Now, your case really seemed to change the course of your life, not just through the legal process, but you also did start this XIV Foundation. Has it been worth it? Fisher didn't change the role of race yet, or draw a bright line in admissions policies. And do you think that, given the conversations you've had through the foundation, the country is ready for it to change?
I think that the country is definitely ready for it to change. I think we have great evidence of that in the ballot initiatives that have passed. Just after my case and Barbara Grutter's case was decided against the University of Michigan, I started a ballot initiative in Michigan. The people of Michigan voted by a 16-point margin to end race preferences in the state of Michigan. That tells you where the people stand, and since then a handful of other states have also passed ballot initiatives. So I do think it's worth it, and it is something that I would do all over again. I will say that it is, leading up to the decision in my case, I was very anxious to move on, to be talking about something other than race. And so it was after the decision, that was another emotional part of it, it was making the decision to continue to fight. And Abigail Fisher has to make that decision as well, because the principal, I've realized that this is a marathon, it is not a sprint. And the courts aren't going to do it for us, the politicians aren't going to do it for us. We have to change the hearts and minds of people and make people believe that equality is the right thing.
Equality is the right thing. Jennifer Gratz, thank you so much for being on the show.
Thank you.
Welcome back to Opinion Journal. I'm Mary Kissel. Back in 2006, Michigan voters decided to ban race-based preferences in college admissions. Now the case is going to the Supreme Court. It's something that all college students or people who want to go to college should pay close attention to. And I've actually got the plaintiff in that case, Jennifer Gratz, here, joining me now. Jennifer, welcome.
Thanks for having me.
Opponents say that this vote to end these preferences violated the 14th Amendment of the Constitution. How? What is that argument?
Well, they say that the simple language that the voters of Michigan passed, which was the state shall not discriminate against or grant preferential treatment to any group or individual on the basis of race, sex, ethnicity, or national origin in the operation of public employment, public contracting, or public education, is unconstitutional. That equality violates the Equal Protection Clause of the U.S. Constitution.
Okay, what is your response to that?
There isn't any amount of mental gymnastics that gets a sane person to believe that equality violates the Equal Protection Clause of the 14th Amendment.
Well, also, how can anyone challenge the wish of Michigan voters? I mean, I thought that if you had a referendum, you decided, a majority here, 56%, said that we want this. How can that be overturned?
58%, actually.
58, excuse me.
Yes, it was a 16-point margin. I've learned that proponents of race preferences, the radical groups like By Any Means Necessary, who's leading the charge on this case, and the more mainstream groups that have joined them, the University of Michigan, the ACLU, the NAACP, that they won't give up, that this is some sort of religion for them, diversity, race preferences, and that they will not give up.
But diversity for diversity's sake?
Yes.
Essentially, okay. The Supreme Court weighed in on this particular issue in a case called Fisher earlier this year. But they didn't eliminate race-based preferences in admissions. So what other signals do you think came out of that case? Was that a good sign or a bad sign?
Two things. The Supreme Court was not asked by Abigail Fisher's attorneys to eliminate race-based preferences. And this case does not deal directly with race-based preferences. It deals with voting rights. So in front of the court today is, do Michigan voters have a right to end race preferences? I hope that in some way the issue of race preferences gets brought up, and that the Attorney General of Michigan, Attorney General Schuette, who's done a great job, that he says that he believes that race preferences are unconstitutional and should be banned permanently.
We've got a couple of statistics I'm going to put up on the screen about other states here that have also banned racial preferences, 8 of them. Does that, and I'm just looking at these numbers now, does that mean that a finding for your side would reverberate far outside of Michigan?
Yes, absolutely. And a finding for the other side would mean that those 8 states, all of their amendments would be called into question. Right now, 28% of the population live in states that have chosen to end race preferences. The Supreme Court, the government has not done it for them, but voters have chosen to stand up for equality, to stand up for colorblind government, and all of that is at stake in those 8 states.
You don't hear a lot about that when you turn on the TV or you read the headlines. Is this something that is very, very recent, or has this been happening over a period of decades? Oh,
it's been happening since 1996. California was the first state to end race preferences in college admissions back in 1996.
Wow, okay. So the case is being heard next month. It's called Schuette versus Coalition to Defend Affirmative Action. We're going to watch it closely.
Sounds good.
Jennifer Gratz, thank you so much for joining us.
Thank you.